matter of Kevin Cromwell versus Carla Cromwell.
For the record, this matter is before the court for pretrial conference. Subsequent parties have engaged in mediation this morning, I believe, with Mr. Walker in front of the court. This hearing is being conducted via Zoom. Present is Attorney Kirsten, representing the plaintiff, Kevin Cromwell. Mr. Cromwell is present. In addition, Attorney Christina Hills is present, representing the defendant, Carla Cromwell. And Ms. Cromwell is present. Good morning, everyone.
Good morning, Your Honor.
Good morning.
Ms. Umik, have the parties made progress toward their own resolution this morning with the assistance of capable practitioners?
Yes, they have a full agreement.
Wonderful. Who would like to place that agreement on the record?
I can do that, Your Honor.
Please, Ms. Umik.
So the parties have 3 minor children. They have agreed that they will share joint legal custody of their children. And Mr. Cromwell's parenting time will be every weekday, so Monday, Tuesday, Wednesday, Thursday, and Friday, from after school or 2:30 p.m. if there is no school until 5:45 p.m. In addition, he will have parenting time every other weekend from Friday after school or 2:30 p.m. until Sunday at 6 p.m. His weekends will commence this weekend, November 22nd. Holidays will be as the parties agree, or if there is no agreement per the friend of the court holiday schedule. With regard to tax exemptions, Mr. Cromwell will be entitled to take all 3, so long as he continues to pay tuition for the minor children to attend school. If the the minor children are no longer enrolled in private school, then the parties would rotate the tax exemptions, with Mr. Cromwell taking 2 in odd years and Ms. Cromwell taking 2 in even years, and the other party obviously taking the remaining tax exemption. When only 2 minor children remain, each party would be entitled to take 1 tax exemption. And then again, when only 1 minor child remains, the parties would again rotate, with Ms. Cromwell taking the exemption for even filing years. I want to clarify that for the parties. It's not the year in which you file, it is the year for which you file that we're talking about, the even and odd distribution. And so Mr. Cromwell would take that 1 tax exemption for odd filing years. In addition, the parties have agreed that they will file their 2024 taxes jointly, that any refund they receive will be applied to the children's tuition. If for some reason there is any tax liability, it would be the sole responsibility of Mr. Cromwell. Child support will be paid by Mr. Cromwell to Ms. Cromwell in the amount of $3,516 per month, commencing January 1st, 2025. This does include an ordinary medical amount of $454 per year per child. The parties have agreed to continue that forward until, someone files a motion otherwise. Uninsured medical expenses would be split, with Mr. Cromwell paying 90% and Ms. Cromwell paying 10%. And this was based on Mr. Cromwell exercising 75 overnights. In addition, spousal support would be ordered in the amount of $1,678 per month. This will be effective the first day of the month after the marital home sells, and I'll get into the provisions regarding the marital home shortly. But as to spousal support, the amount is modifiable. However, the duration is not modifiable, and it will continue through January 31st, 2031, which will include the time it takes the house to sell. The parties have agreed that Ms. Cromwell will be able to remain in the marital property up to 24 months until the house is sold. In the interim, Mr. Cromwell, in lieu of spousal support, would be paying that mortgage payment, which is approximately $2,300 per month. And again, that would be until the sale of the house. When the parties list the house for sale, they will agree as to the realtor, the listing price, and will work together through any offers and whether or not to accept or reject them. The house needs a few repairs, and the parties have agreed that they will agree to a contractor, and Mr. Cromwell will pay all of the expenses with those related to those repairs. He will get half of what he pays for those expenses from the proceeds of the sale before the proceeds are split evenly. So he'll be entitled to reimbursement prior to splitting the proceeds of the sale. Any damages to the house, any repairs that become necessary from this date forward, if they are the result of normal wear and tear or caused by the children's or the party's children, then the parties would be equally responsible for those repairs. However, if any damage was caused solely by Ms. Cromwell, she would be 100% responsible for those repairs. With regard to debt, the parties have some outstanding medical bills through ProMedical. Ms. Cromwell is going to be responsible for those. They also have some outstanding orthodontia bills with Dr. LeBeau, and Mr. Cromwell is going to be responsible for those. Otherwise, each party is going to be responsible for the debt in their own name. Ms. Cromwell, there's some amounts owed to her mother and to her sister. She is going to be responsible for the repayment of all amounts owed to her sister. However, with regard to the amount owed to her mother, Mr. Cromwell will pay $3,952 by January 2nd of 2025, and Ms. Cromwell will be responsible for the balance. There are quite a few vehicles here. With regard to the 2020 Ford Explorer, Ms. Cromwell is going to be entitled to retain that vehicle. Each party is going to pay half of the loan until that vehicle is sold or traded in, which will occur no later than August 1st, 2025. If she has not sold or traded that 2020 Explorer in by August 1st, 2025, she will be responsible for all of the debt associated with it from that point forward. Mr. Cromwell will also pay the insurance for that vehicle until it is sold, traded in, or August 1st, 2025. Ms. Cromwell would be entitled to any proceeds from the sale or trade-in to use to purchase a new vehicle. In addition, during this time, while the parties are splitting the payment of the loan, Ms. Cromwell would be responsible for all of the normal upkeep related to that vehicle, oil changes, tire rotations, all of those things. In addition, Ms. Cromwell will retain a 2002 ATV side-by-side, a 2020 trailer, and the Cub Cadet mower. Mr. Cromwell will retain the 2011 Lincoln MKX and a 1979 30-foot Sea Ray. The parties are going to be responsible for all the costs and liabilities associated with each of those vehicles. The parties will divide personal property as they agree. With regard to bank accounts, Mr. Cromwell is entitled to keep all of the bank accounts that are at Advantage One. I believe that's a credit union, and those are currently in his name. There are some joint accounts at First Merchants Bank. The parties will cooperate to remove Mr. Cromwell's name from those accounts. However, his name will stay on the account and the parties will pay all of the December bills and not remove him until January 1st, 2025, at which point the contents of the accounts would be split. The parties, Mr. Cromwell has a retirement account. It has a zero balance. Ms. Cromwell has no retirement accounts. So any retirement accounts the parties have currently or have in the future will be their own, free and clear of any interest of the other party. There are whole life insurance policies. Each party is going to be entitled to keep the insurance policy on themselves. There are also insurance policies for each of the children. Mr. Cromwell will maintain those insurance policies. He'll be responsible for paying those premiums, but both parties will be named as beneficiaries with a 50-50 split. And Ms. Cromwell would like the option to restore her name to Carla Kyko, which is Kyko, should she choose to do so in the future. And I believe that's the entirety of the agreement.
Thank you, Ms. Nemick. Ms. Hills, did Ms. Nemick accurately state your client's agreement this morning?
She did great. Just a clarification or two and an addition. probably goes without saying, but since the parties are filing their 2024 taxes together, we are holding the judgment until after the first of the year. That's assuming the court will allow us to waive part of the balance of the 6-month waiting period, which we'll address in testimony. The parties did agree to a mutual right of first refusal for childcare. Relatives would not be counted as childcare providers or babysitters for purposes of that provision, and that would be when either party would be away from the children for 4 hours or more. Also, just to clarify, the tax exemption provision would start with tax year 2025, since they'd be filing together for 2024. I believe the agreement was that the parties would agree as to the repairs that were necessary to the marital home that Mr. Cromwell would pay in advance, and that they would need to be agreed to in order for that sharing of cost ultimately to take place. Any of the debt assigned to either party, we would include standard hold harmless language. And with that, I believe that is the entire agreement.
Ms. Nimick, are those clarifications acceptable?
Yes.
And with respect to the 2024 tax returns, how will the parties handle any liability or refund?
If there's any refund, it will be applied to the minor children's tuition at Monroe Catholic Elementary Schools. And if there's any liability, it would be entirely Mr. Cromwell's responsibility.
That's correct.
Yeah. All right, very well. For that clarification, thank you. Very well, Mr. and Mrs. Cromwell, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. And Ms. Nimick and Ms. Sills, the court would note that the statutory 6-month waiting period expires in March of 2025. And yes, if both parties are requesting the court to waive the balance under the judgment in January, the court would do so. So you can perhaps address that during your voir dire of your respective clients. Ms. Nimick, if you can begin with Mr. Cromwell, please.
Yes. Kevin, can you state your name for the record?
Kevin Joseph Cromwell.
Okay, and you are the plaintiff in this action for divorce, correct?
Yes,
At the time that you filed your complaint for divorce, had you lived in the state of Michigan for at least 180 days?
yes,
Had you also lived in the county of Monroe at that time for at least 10 days?
yes,
There are 3 children born of this marriage, correct? Rocco, Leo, and Hazel?
yes,
And they are 12, 8, and 4?
yes,
Okay. And are you, to your knowledge, is Ms. Cromwell currently pregnant?
no,
Okay. And are you stating to this court that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no likelihood that the marriage can be preserved?
yes,
Okay. Did you hear the agreement that I read into the record?
yes,
And you heard the clarifications that Ms. Hills made?
yes,
Did those statements accurately reflect your understanding of the agreement that you came to today?
yes,
And you got to participate in coming to that agreement through mediation with Mr. Walker, right?
that is correct.
Okay. Is there any part of the agreement you don't understand?
No,
Do you have any questions about it?
no,
Have you had time to think about it?
yes,
Have you had time to discuss it with me?
yes,
Is anyone forcing you or coercing you to enter into it?
no,
Okay, with regard to the agreement regarding your children and custody and parenting time, do you believe that the agreement's in their best interest?
yes, it is.
Do you feel that the property settlement that you've come to today is fair and equitable?
Yes,
Do you understand that by putting it on the record today before the judge, that makes the property settlement binding on you?
yes,
You know that you can't come back tomorrow or a year from now or any time in the future and ask the judge to make any changes to the property settlement.
yes,
So you can't come back and ask to have spousal support awarded to you.
that is correct.
Okay. You understand that you could have taken the case to trial and the outcome could have been different.
Yes,
Okay. Could have been better or worse. But instead of going to trial, you're asking the court to adopt the agreement that we read into the record and make it an order of the court.
yes, I am.
Okay. Have you disclosed all of your assets to Ms. Cromwell?
Yes,
Okay. Are you satisfied with my representation?
yes,
And then finally, you've heard us discuss today the waiting period, that there is a 6-month statutory waiting period. Are you asking the court to waive that and sign the judgment of divorce when we present it in January?
yes,
And are you doing that because you believe that it's in yours, Ms. Cromwell's, and the children's best interest to have some finality and start moving forward?
yes.
Okay, I have nothing further, Your Honor.
Thank you, Ms. Nemick. And Ms. Hills, first of all, do you have any questions for Mr. Cromwell?
No, Your Honor, thank you.
Questions for Ms. Cromwell, please?
Yes, Ms. Cromwell, would you state your name for the record, please?
Yes, Carla Keiko Cromwell.
All right, are you pregnant, Ms. Cromwell?
No,
And have you heard the settlement agreement, which has been placed on the record by Ms. Nemick and myself?
yes,
And did you understand all of its terms?
yes,